as an exception, as a restriction or a qualification on the freedom of speech and expression. But within a very short while, they say less than a year or just about a year, the story was to change, because we had been seeing the occurrence or recurrence of these offenses, of this crime. It was thought that it should be made into a crime by itself. What is the change that is proposed? Why is it proposed? You may agree with it, you may disagree with it. But you must know before you agree or disagree, what are you agreeing or disagreeing with? And that you're not critiquing something or criticizing something for the sake of criticism. However, I'm here to discuss with you a couple of aspects of the Bharatiya Nyaya Sanhita, and I will be adding to your repertoire of knowledge. Now, there are three topics within Bharatiya Nyaya Sanhita that we will be discussing today. And I don't know how many of you are aspiring to be lawyers. If I don't see any hands going up, all right, couple of them, yes, good. So, but the majority are not going to be lawyers. So I'll try and simplify for your understanding and for your comment and discussion what I'm going to say. I'll try and use as many non-legal words as possible. So as we all know that the three topics that we're discussing are sedition, as Weber told us. Second is the offenses against children. And third is a few aspects of the changed scenario for punishment for murder and mob lynching, etc. So I'll begin with something that is very close to my heart, and that is the topic of sedition. Now we all know, and I'm sure you all have learned, that those who do not remember or take lessons from the history are condemned to repeat it. We must therefore understand what is the concept of sedition, how it evolved, and what is it that the law proposes to change in that. So in the original penal code, which came to be drafted as a statute by Lord Macaulay in the early 19th century, included a section. Now sedition as an offense came very close to a colonial power. The colonial power didn't want the natives express in any manner, whether in writing or vocally, any criticism of the government. In other words, in the colonial mindset, the state was synonymous with the government of the day, whether elected or unelected, representative or unrepresentative. They felt that we are governing, we are ruling over India, and any criticism of the government should be made punishable. Anyhow, it didn't creep into the Indian Penal Code 1860 for reasons that at least I don't know. But it was brought in 10 years later into the IPC as section 124 capital A. The words of 124 capital A as brought into IPC were very interesting. They made punishable any criticism of the government of the day. In other words, according to 124A, just the criticism of the government was enough for someone to be prosecuted for sedition. Now, criticism was described through certain very vague general terms like whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law. Now you'll be wondering as to what is disaffection. It was as loosely understood by the courts of the day back then as it is by the language. The court said disaffection means lack of affection. So you must love your government. If you don't love your government, you are liable to be prosecuted. That was the concept as was brought in to the statute by the British. Now we've all read fair bit of the political history and how most of our political leaders who took part in the independence struggle suffered one way or the other, regardless of which thought they came with. You had within the Congress several segments of thought, and you had outside of Congress several segments of thought, but all of them suffered, and some of them also suffered for prosecution under 124 capital A. So as a result of which, when we became independent in 1947, the dominant political thought was that we must unshackle ourselves. We must unshackle ourselves from the vestige of the British era, namely, criticism of the government is something which is a part of freedom of speech and expression. A government of the day should be open to be critiqued, criticized, and should not be sensitive to its criticism, at least not such that it would start prosecuting people for showing disaffection to the government. When the Constitution was being drafted by the Constituent Assembly, we had a draft Article 13 in the draft Constitution. Article 13 ultimately became Article 19 in the Constitution as came to be adopted by the Constituent Assembly. Article 13 envisaged that sedition should be made as a qualification, as an exception, as an aspect that overrides the freedom of speech and expression. So, in the draft article as originally proposed, it was proposed that freedom of speech and expression can be curtailed by a law which deals with sedition. Then it was debated by the Constituent Assembly. And when it was debated by the Constituent Assembly, the thought that emerged was this, that sedition is a British relic. It should be removed from the draft Article 13, and we should not have the law of sedition as a qualification, as an exception, as a carve-out, or as a restriction on the freedom of speech and expression. Now, this thought of removing sedition from draft Article 13(2), which became 19(2) in the Constitution as adopted, were carried the day, and in the Constitution as came to be adopted by the Constituent Assembly, we did not have sedition as an exception, as a restriction or a qualification on the freedom of speech and expression. But within a very short while, they say less than a year or just about a year, the story was to change. The story changed why? There were a number of judgments that the courts gave in 1950, particularly 50 and 51, where the courts, particularly the Supreme Court, construed the fundamental rights which are guaranteed to all of us under Part 3 of the Constitution as something which was uncompromisable, something that could not be curtailed. So you had several laws declared as unconstitutional. You had land reform laws declared unconstitutional. And likewise several, including 124 capital A. The Punjab and Haryana High Court, Punjab High Court at that time, not Punjab and Haryana, Punjab High Court at that time declared it to be unconstitutional. All of this enraged the then Prime Minister, Pandit Jawaharlal Nehru. So he planned to amend the Constitution. within a year of the Constitution having been adopted. And I must tell you what were his opening words when he moved the First Amendment Bill in the Parliament. He says, somehow we have found that this magnificent Constitution that we had framed was later kidnapped and purloined by lawyers. So we are a community that I belong to, which is much abused in the sense that we are responsible for quite a few changes in law. Pandit Jawaharlal Nehru was no exception. He also blamed lawyers for having subverted in some way his progressive ideas, progressive policies, and therefore he said it's time that we bring an amendment to the Constitution. Now, this First Amendment was preceded, very importantly, as I said, by some very, very path-breaking judgments of the Supreme Court, some of which guide our path even to date. One of them dealt with censoring Organizer, the then government of Delhi. That censoring of Organizer was challenged. Supreme Court struck it down, saying that it is violative of freedom of speech and expression. This all the more enraged Pandit Jawaharlal Nehru, who had complete scorn for the Organizer or the people behind it. And that philosophy, particularly in those sections, continues to date. However, coming back to the story, so what happened was this. He said it's time now to curtail the fundamental rights. They can't be unbound. And he said this idea about the freedom of speech and expression, the human liberty, are ideas of the 17th, 18th, and the 19th century. We are now in the 20th century. These ideas have to be peppered, conditioned, controlled by the idea of social development, by the idea of economic progress, of equality, and so on. So he said, let us amend the Constitution. Not many people were happy. In fact, at that time, a lot of persons who were a part of the Constituent Assembly, because the Constitution came to be drafted and adopted in 1950, a year back, revolted, saying that, well, this is not what Pandit Nehru was proposing to do with the Constitution is incorrect. He shouldn't be doing it. However, the Constitution Amendment Bill, the First Amendment, was carried through in the Parliament, and the Constitution came to be amended. Of course, sedition did not form part of Article 19(2). However, it was in no one's mind, no one had a doubt that sedition now in spirit, if not in letter, in spirit, was a qualification on the freedom of speech and expression. So the issue came up again before the Supreme Court shortly thereafter, where the constitutionality of 124 came to be challenged. Now, this is a very celebrated judgment of Kedar Nath Singh. This was reported in 1962 Supreme Court, AIR 1962 Supreme Court 955, a judgment of 5 judges of the Supreme Court. They tried to strike a balance between the Nehruvian thought, which was the dominant force for the First Amendment, and the freedom of speech and expression, which many believe to this day, and quite rightly, is the soul and heart of democracy. You cannot have democracy without freedom of speech and expression. However, no freedom can be meaningful if it is uncontrolled, if it is unlimited. Because the freedom which is unlimited is no freedom at all. So therefore, the Supreme Court was doing a fine balancing act. And Supreme Court had the letter of the law before it. 124A said, disaffection towards the government. We just heard that. Disaffection means lack of affection for the government. So Supreme Court said, well, the bar for prosecution under 124A is too low if we go by the plain words of the statute. Now, it is important for those who are students of law, whether you want to do law or otherwise, that the principle that is followed by the courts while interpreting a penal statute is that of strict construction. Meaning thereby, you will read the word strictly and you will not take anything out of it or incorporate anything into the section. The section should be read as is. That's the principle of interpretation. Supreme Court found that if it were to adopt that principle of interpretation, literal interpretation of 124A, it was staring at a problem. The problem was that we go back to the colonial days where once again and yet again, lack of affection for now the government of an independent republic called India could be prosecuting people just the way the Britishers were, that any lack of affection for this independent country's government would be sedition. So Supreme Court defined the contours of sedition to say, well, not every form of disaffection, not every expression, not every act, but any expression or act that is calculated or motivated to create public disorder. So therefore, if I call upon a group of people, defined or undefined, or suppose I were to provoke you into saying, let's go on and let's gherav the parliament and let's start physically assaulting the members of parliament. We want to bring the government down through armed rebellion. That would be sedition, because the thought and expression are calculated to create public disorder, to violate law and order, to create an armed rebellion against the government. So that was Kedarnath. Then of course, initially 124A, now this is a topic where I will have to get into some kind of legalese, was non-cognizable. In other words, that a police officer could not simply go and arrest a person who was accused of sedition. They had to follow a process. In the 70s, the law was amended to include, to make 124A cognizable, which means that the police officer could go and arrest a person accused of sedition. Now, all of this boiled over of late, where the courts found that the law of sedition is being misused. And this is regardless of who is the ruling government of the day. More often than not, for political reasons, persons came to be prosecuted. Whether they were convicted or not is a separate measure, is a separate topic, but they came to be prosecuted. So courts found from the experience that we gained over the last 50, 60 years that the law of sedition is being abused more than it is being used. In between, you also had the Law Commission, which commented on whether or not this section be retained in the penal code or should it be deleted. Because there was a stream of thought saying, well, sedition is British relic, it's colonial, it's history, it must be consigned to dustbin, it must be taken out of the penal code. Law Commission came with a report, 279th report, where the Law Commission said, well, that's not correct, that's not the way to approach it. Yes, it is being abused. The best course of action, therefore, would be to amend the letter of the law. Now, I hope you're paying attention. The letter of the law, that is 124A, was reading very different from how the Supreme Court had read 124A. So, the police officers who would register an FIR did not have the benefit of reading the judgment of the Supreme Court in Kedarnath Singh. They were going by the letter of 124A, and that was their understanding of 124A. And as a result of which, a lot many FIRs came to be lodged, which could never have been lodged if they were to follow the law as laid down by the Supreme Court in Kedarnath Singh. In other words, the police was following the law literally, which was not the law. The law was what Kedarnath Singh had held. So all of these debates, different chains of thought, are presently before the Supreme Court, and the Supreme Court says, well, while the Supreme Court is considering the constitutionality yet again of 124A, no further prosecutions be initiated. Now there are empirical studies as to how many prosecutions have happened of people under 124A. Of that, how many have succeeded? That's a debate for another day. The question that we have to debate is, suppose a law is being abused or is capable of being abused. Is that a reason enough for that law to be repealed, for that law to go out of the statute? Now, here comes a very important and a path-breaking development in the legal history of our country with the introduction of Bharatiya Nyaya Sanhita. This is supposed to revolutionize the criminal justice system. Indian Penal Code, we are going into Nyaya Sanhita. Britishers wanted to penalize, they wanted to punish. That was the dominant purpose of the Indian Penal Code, and that's why it came to be called Indian Penal Code. The subjects, the natives, have to be punished if they violate the law. They did not have the evolved, they did have a sense of, or an evolved sense of justice, but that was for their own. It was not for the colonial subjects. Justice really had not much place when it came to ruling a colony. Much can be said about it. So therefore, the law really at its heart was only for punishment, not so much for reformation. Now you have therefore, with the introduction of Bharatiya Nyaya Sanhita, an attempt by the Indian Parliament to bring a lot of new thoughts into the criminal justice system. With the experience of about 60, 70 years that we've had. So with this, now what becomes of the law of sedition in the short time that I've dealt with the history? Bharatiya Nyaya Sanhita tells us that we are not confining 124 to the dustbin. We are going to retain 124 in the statute book. But mind you, in a very different form. Now this form not just confirms to Kedarnath Singh, but more importantly, it also answers another criticism of sedition, where the section used the word disaffection for the government. In other words, any criticism, disaffection of the government was punishable, meaning thereby that 124A said government is synonymous with the state. I hope I'm making my point clear to you. Government is not the state. We've heard, and I don't know if any of you were born, I think nor was I at that point, but we have read as students of political history that during emergency, a slogan was adopted: Indira is India, India is Indira, thereby conflating the persona of the then Prime Minister with the Republic, with the country, with the state. Now the new section answers this by replacing government with state. Now allow me to read to you the new section, which is clause 150. This reads as follows: whoever purposely or knowingly, please note the words, they are very important because each word in a section is very, very important. It has to be given its meaning. So whoever purposely or knowingly, by words either spoken or written, or by signs, or by visible representation, or by electronic communication, or by use of financial means, or otherwise, excites or attempts to excite secession or armed rebellion, or subversive activities, or encourages feelings of separatist activities, or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life or with imprisonment which may extend to 7 years, and shall also be liable to fine. There is an explanation added to it. Comments expressing disapprobation of the measures or the administrative or other actions of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section shall not be sedition. Which means that criticism of the government, trying to tell the government that, look, your view is wrong, you must change it for reasons A, B, and C, is not sedition. So this takes us back to what Kedarnath Singh said: the heart and soul of democracy is criticism of the government, fair or unfair. Criticism may be unfair, but the government can't be so sensitive as to keep prosecuting citizens for even an unfair criticism of its policies. So now you have government being replaced with the country, and the section has been expanded to include other activities which back then in 1870, when it came into the statute book, or in 1950, could not have been foreseen. What are they? Use of financial means, funding, electronic communication, and so on. So even the section, if it were to be 124A, if it were to be read in the context of Kedarnath Singh, it was debatable as to whether these concepts could be fit into that section. They could only be fit into the section by way of some kind of a judicial interpretation, by the courts reading into the section that, well, what you're doing is indirectly you're funding this activity and therefore you're also equally guilty. But now we have a section which is proposed in clause 150 of the Bharatiya Nyaya Sanhita. Now this Nyaya Sanhita has been referred to a committee for their report and comments, which is awaited, and let's see how it and where it goes. But certainly when it comes to law of sedition, clause 150, it is my view, and I'm open to debating it with you, that it puts 124A on the right track. It brings the letter of the law close to what the law was, but was unknown to people who were trying to enforce it. This now takes us into the next section that I am discussing with you, and which is murder. Why is it important? I'm sure a lot of you would have seen movies or otherwise read in the newspapers or in fiction and other works, 302 IPs. So murder is punishable. Whosoever intends to kill and kills another human being is guilty of offense of murder. That offense is punishable. We've all learned that the statute, the Bharatiya Nyaya Sanhita, is no exception to that thought, because that's the right thought. But where it brings in another thought to add to this is by including a clause 2, by including clause 2 to clause 100. 1. To clause 101, it introduces clause 2. And clause 2 reads as follows: when a group of 5 or more persons acting in concert commits murder on the grounds of race, caste, or community, sex, place of birth, language, personal belief, or any other ground, each member of such group shall be punished with death or with imprisonment for life, or imprisonment for a term which shall not be less than 7 years, and shall also be liable to fine. Now we've read in the newspapers incidents of mob lynching, where you have a group of people who's incited or excited and commits the offense of murder. Now, when this group commits an offense of murder, it was debatable whether all the members of the group, not just the person who assaults the victim, but whether all the members of the group could be punished under section 302. For all the members of that group to be punished under section 302, the prosecuting agency had to establish what is called as a common intention, which means that all the members of the group, not just the person who's assaulting the victim, but all those who participated in that assembly and charged, had the common intention of committing the murder of the victim. Now, to establish common intention is a tall order. I may participate in a mob, and my intention may not be to kill the person. My intention may be to possibly agitate, at times physically, against that person. But as a result of that, the person dies. Now, can I be accused of committing an offense of murder? Debatable. But because we had been seeing the occurrence or recurrence of these offenses, of this crime, it was thought that it should be made into a crime by itself. So now in that light, let's read clause 2 of clause 101. When a group of 5 or more, so the minimum is 5 plus, acting in concert, which means they're all together acting as one, commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other reason, each member of such group shall be punished with death or with imprisonment for life. So now you have clause 2 of 101, which says if 5 or more people have assaulted a human being and that human being has died, and that assault is for the reasons that are mentioned, that each of them would be guilty of murder and can be punished under clause 101, subclause 2, for the offense of murder. So you have mob lynching being recognized as murder, and that is something new. Earlier, the prosecution would have to incorporate a few sections to say, well, this is a mob, they had a common intention, and so on and so forth. The problem here is it leaves out some ambiguity. And what is that ambiguity? The moment you have, the offense is if there is a group of 5 or more, and the expression is acting in concert. So if 2 of the 5, if 2 of those 6 or 2 of 5 plus say that, well, we were told that we were going to meet Mr. A, we never knew that he is going to be assaulted, then of course that will be their defense. For a conviction under 1012, the prosecution would still have to establish that they were acting in concert, meaning thereby all of them had gathered to assault this person so as to kill him or her. Personal belief, sir, is not ambiguous. It could be related to, let's go delve into a recent history. It could be related to my culinary preferences. I eat something, I don't eat something. That doesn't give anybody else a right to kill me. You may critique me, you may criticize me, you may not agree with me, but you can't kill me for it. So personal belief is also not an ambiguity. The ambiguity is or any other ground. Now, how do you define what could be the other ground for someone to be prosecuted under 1012? That leaves a large canvas out and open for a prosecuting agency to invoke at will 1012 and say, well, this is the other ground for which I'm charging all of them with murder. That other ground would not be a ground related to race, caste, community, sex, place of birth, language, personal belief. It could be any other ground. According to me, this needs to be debated. Maybe the committee would give its opinion, it would give its observations, and maybe while this section is being debated in the parliament, they may want to curtail or define at least of and define this term or any other ground. Equally important, it leaves out on the basis of religion. It leaves out that the basis of charging or death or causing death on the basis of religion. But possibly, as a student of law, I would say that religion could be covered by the expression or any other ground. That could be a possible interpretation. Nevertheless, there is some ambiguity here which I feel the parliamentarians must look at, so that in future this Sanhita, which is an extremely important thought in reforming the criminal justice system, is not abused in future. That brings me to the third topic, and which is relating to rape, atrocities or sexual offenses against children, and so on. Now, I am running a bit short on time, so I'll be quick here. Not because I do not wish to deal with it in detail, but I have a flight to catch, so you'll pardon me for being a little quick with this topic. So, traditionally in the Indian Penal Code, the thought is, and please don't mind my saying that only a woman can be raped. A man can't be raped. Only a woman can be subjected to a sexual offense. A man cannot be subjected to sexual offense. A transgender cannot be. So in certain sections, the Bharatiya Nyaya Sanhita now attempts to be gender neutral. I am sure this is a topic that is debated close to your hearts. This is the new language that we talk about these days, gender neutral. Absolutely, that's the way forward. So the Penal Act, which was so far not gender neutral, is sought to be made gender neutral in certain terms, in certain sections. So wherever you found woman, it's replaced with person. I'll give you a few examples. The offenses were relating to women. They have now been made into person. Just kindly give me a moment. I seem to have lost that part of my notes. So this is in 75. Let's look at 75. 75 originally read, which was originally 354B in IPC, read as assault or use of criminal force to woman with intent to disrobe. 354B. This is now changed. The language of the section, was any man who assaults or uses criminal force to any woman or abets such act with the intention of disrobing or compelling her to be naked shall be punishable. Now in the new clause, which is 75, the new clause reads, whoever, not just a man, but whoever, assaults or uses criminal force. So even if a woman is assaulting another woman, she will be punishable under 75. Earlier, a woman assaulting a woman in the form that is covered by 354B could not have been prosecuted. Likewise, 76, which is the rechristened version of 354C, where 354C said, any man who watches or captures the image of a woman engaging in a private act in circumstances where she would usually have the expectation of not being observed, and so on and so forth, shall be punishable. Now the new clause says, whoever watches or captures the image of a woman engaging in a private act, and it goes on. So a woman committing this offense is now also punishable with the expression whoever. You have similar changes in relation to minors. So you have a 336A, which was in IPC, which said, whoever by any means whatsoever induces any minor girl under the age of 18 years to go from any place to do any act. So this was only with respect to a girl child. 336A. Now 94 of the Nyaya Sanhita says, whoever by any means induces any child, so girl child or a male child is on an equal footing now. If this offense is being committed in relation to a male child, that is made punishable. Likewise, you have 372, which is rechristened into section 9, into clause 96, and so on. So there is an attempt now to make certain sections gender neutral. Has it gone through? In the sense that has it gone through each one of those offenses that deal with a bodily or a sexual offense? It's not that. And that's where perhaps Bharatiya Nyaya Sanhita needs to be supplemented, and this thought needs to be addressed in the Nyaya Sanhita. Like, for example, rape continues to be rape of a woman. Rape of a man still is not recognized by the Nyaya Sanhita. So therefore, there are several examples. For want of time, I am unable to share them with you, but there are several examples where the Nyaya Sanhita has traveled to make the penal sections gender neutral, but there are several other instances which I feel that the draftsman need to look at. Now, those were my thoughts that I wanted to share with you. Having said that, I just wanted to leave a thought with you before we open ourselves to questions. A lot of time we find that criticism of any act or any literature or for that matter any bill, uninformed criticism for the sake of criticism. So you have a thought process which says, well, why reform, why amend IPC, why reform the criminal justice system when you've had this statute for the last 170 years? Why change it now? Why do you want to change it? But the law is a living organism. It must address itself to changes. If the law doesn't change, it will be condemned to the dustbin. It must keep pace with the changes in the society. And we must, therefore, and that I'm sure is the purpose of this debate, short as it is, but meaningful it is, to review it meaningfully, to review Bharatiya Nyaya Sanhita meaningfully, and to know what is the change that is proposed, why is it proposed. You may agree with it, you may disagree with it, but you must know before you agree or disagree, what are you agreeing or disagreeing with, and that you're not critiquing something or criticizing something for the sake of criticism. Thank you so much. That's right.
Good afternoon, sir. Sir, my first question is defamation as treated as sedition, and also you said in sedition, verbal and vocal and written things. In defamation, also label and slander is described, and also contempt of court is also treated as sedition in Article 124 capital A.
Well, to answer your question, it's a very interesting question, but to answer the question, defamation is a completely different concept. So defamation is not a part of 124 capital A. Was never, even as existing today. Nor was contempt of court. Contempt of court, as you know, is showing disrespect knowingly to an order that binds you. That is not sedition. Sedition, as per Kedarnath Singh, and now in terms of clause 150 of Bharatiya Nyaya Sanhita, is inciting or exciting a group of people or any group of people through oral or other forms of communication to act in a way that would violate the sovereignty, integrity of the country. So sedition is an offense against the state versus contempt of court, which is an act of disrespecting the court, or defamation, which is disrespecting an individual.
Myself Ankit Jaiswal from Satyavati College, Department of Political Science. Sir, in Sanskar Marathi versus State of Maharashtra, essay upheld the strong criticism of government does not account for sedition. But sir, in current time, present government ऐसा हुआ कि उन्होंने बहुत सारे केसेस ऐसे हैं जो जर्नलिस्ट और अपोनेंट के अगेंस्ट सिर्फ सेडिशन केस क्रिटिसिज्म के बेसिस में हुआ, और प्रेजेंट टाइम जो न्याय संहिता आईपीसी को रिप्लेस की है, उसमें आर्टिकल सेक्शन 194A को 350 से रिप्लेस किया गया, सेक्शन से, सॉरी 150 से। बट सर इशू है कि जिस गवर्नमेंट ने इतने सारे सेडिशन केस फेक लगाए हुए हैं, ये एससी हाई कोर्ट दोनों ने कहा है कि बहुत सारे फेक केसेस हुए हैं, वो खुद रिप्लेस करे, तो हम कैसे कह सकते हैं कि जो हमारी नई आईपीसी की जिसने रिप्लेस किया है वो चेंजेस ला सकती है सर, क्योंकि उस गवर्नमेंट ने सब ज़्यादा मिसयूज़ किया है उस लॉ का।
देखिए, आपका सवाल थोड़ा सा लीगल है, काफ़ी कुछ पॉलिटिकल है, तो जो लीगल पार्ट है उसका मैं आंसर कर देता हूँ। लॉज जो है वो गवर्नमेंट नहीं बनाती, लॉज पार्लियामेंट बनाता है। सो पहली बात। दूसरी बात, भारतीय न्याय संहिता अभी लॉ नहीं बनी है, उसको लॉ बनाने का प्रपोजल है। तीसरी बात, जहां तक प्रोसिक्यूशन का सवाल है, तो हर एक केस अपने फैक्ट्स के ऊपर डिपेंड करता है। आई डू नॉट नो, अगर आपको मेरे को एक पर्टिकुलर फैक्ट सिचुएशन मेरे सामने रखेंगे तो उसका मैं आपको जवाब दे सकता हूं कि सारे ही के सारे प्रोसिक्यूशन गलत हैं, and therefore we have no faith in the government that is prosecuting people. That is also wrong, because it is not the central government that prosecutes people under IPC, it is the state government that prosecutes people. So that's why I said, see, please remember, Machiavelli, the French philosopher, wrote a very celebrated book. It's called The Republic, like our Kautilya. And he, in the preface, wrote something very important, and that was the reason why I shared the last thought with you. He wrote, and I'm not quoting him because I don't remember the exact words, but this was the purport of what he said. Critique the book by all means at your command, but critique it after reading it.
Morning, sir. I'm Nitin Khanna from campus. Sir, my question to you is, you in the last part of your talk, you told about the laws against crime in women, against women. In the new Achar Sanhita, they are talking about the women centrism. Law and social transformation is happening for 170 years from where women were oppressed. Now there is empowerment and equality. So when will this mindset change that men and women are equal and they should be on the equal footing as far as crime is concerned?
Well, again, I'm not equipped to answer that question because it's a political question. When will it change? I can't see or gaze in the future. But said that, you make a very, very important point. Law, particularly a penal law that creates an offense and punishes the subject, has to be gender neutral in every respect. You're absolutely right. And that's one of the thoughts that are being advocated for making this Sanhita better than what it is right now. And I'm hoping that your thought carries the day, and most importantly, the sections that are relating to bodily or sexual offenses, they should actually be made gender neutral, because we live in a society where you could have, although exceptionally, but you could have instances of one gender oppressing another, and that the oppressor may not ordinarily and always be the male oppressor. It could be a female oppressor.
Good afternoon, sir. Myself, Anuj from Satyavati College only.
Please.
Sir, my question is that, sir, according to antagonist, they argued that Section 124A was enacted by the British and is a colonial provision. And in order to suppress the emerging nationalist tendencies and democratic spirit among the people of India, therefore, it is a anti-democratic in nature, and it doesn't deserve a place in the democratic and political people, and criticizing the government and its policies. Even the legitimized criticism against the officials is not possible, and thus it affects the freedom of speech and expression, and it's unconstitutional and void. So how would you deal with that, sir?
Well, I don't know if the author of that piece that you just read had read the Bharatiya Nyaya Sanhita. And I would once again repeat what Machiavelli told us long back, several hundred years back. That look, critique it by all means, but after understanding and reading it. Now, I have not heard from you or in that comment as to what is wrong in clause 150. Let's take an example. We have had a situation in Canada. All of us have heard about it, we have read about it, we have seen it on the TV, in the news. Now, if that were to happen in India, namely that a particular group of people start demanding a separate nation, a carve out from this country, would that be a freedom of expression? Or would that be sedition? Should it not be punished? If suppose tomorrow you and I come together to say, well, we want a separate nation, we don't want to be a part of India, we don't recognize the laws of India, we want to secede from India, is that not grave? Is that not injury to law and order? Why don't you ask yourself? Those who are critiquing the law of sedition are doing it in the blind faith in the freedom of speech and expression. But even in the present context, even in the Constitution, freedom of speech and expression is not unbound. It is bound. There is a qualification in 1902. We are forgetting that. And it's not the government of the day that gave us the Constitution. So therefore, the Constitution makers gave us the Constitution. Your freedom of speech and expression is conditioned, restricted by the restrictions contained in 1902. So, as I said, a lot of criticism, right or wrong, everybody has a right to criticize, is, as a student of law particularly, I find, people don't know what they are saying, but they say it because it sounds better, or more acceptable, or more palatable to a group of people who are hearing it. And that's one thing can be said about it. Take, for example, a safety pin. A safety pin can be a very important equipment or article when you need it in a situation. It can also be a weapon. It can also kill you. Does it mean that you will ban safety pin? So you could have one section, you could have one law which is capable of being abused. What can't be abused? Everything can be abused. A footwear can be worn in the foot, or can be used to abuse somebody or hit someone. Does it mean that you will ban footwear? So therefore, criticism for the sake of criticism is no criticism at all. If the law is taking a turn for the worse, challenge it, question it, debate it. But just because somebody who's proposing the law is unacceptable to you as a part of as political thought process, well, that's no criticism at all. Critique the content. How is the content wrong?